welcome to another Tort Talk Thursday. Here with Joe Fantini every week, getting updates and insights on what's happening in the world of mass torts. Joe, as always, thanks for taking time to connect with us.
Susan, thanks for having me. Really excited to talk to you this week. We got some awesome positive developments that we'll get into. Thanks again for having me.
Yeah, for sure. Okay, well, let's dive right in. Why don't we get an update on the Bard Hernia Mesh settlement? What's going on there?
Finally, some great news on this litigation. It's been going on for 6+ years, and we've been seeing and reading the tea leaves about a potential settlement for about 6 months since the court canceled the fourth bellwether trial. What we saw was about a week ago, two law firms tried to file a motion for a qualified settlement with a few hundred cases. The judge denied that request where they sought to keep the MSA under seal. And then recently what happened was there appears to be a settlement, even though the final details are still being hammered out, because in both the MDL and Rhode Island State Court, the courts entered Lone Pine orders. So the Lone Pine order requires the parties, the plaintiffs, to do additional discovery, to do a full-blown plaintiff fact sheet, to also get expert reports and serve them soon after filing the complaint. So the details haven't trickled out yet, but I'm hearing it's going to be for 35,000 cases. We'll get the details here in the coming weeks, and stay tuned to Tort Talk Thursday to get all the updates on that.
Awesome. That sounds great. That is positive movement. Okay, next, let's talk a little bit about baby food. What are the updates with that litigation?
Toxic baby food. This is another one that we're really excited about. We had the MDL formed earlier this year, and we've been moving forward. So usually the first 6 months of an MDL is the housekeeping, where we're getting leadership in place. We're agreeing on discovery. We're doing the long form, short form complaint. But the biggest hurdle, and what we always have to go and overcome first, is going to be this motion to dismiss the complaint. So the court just entered the order. July 15th, we have to file the master long form complaint. There's going to be briefing back and forth that's going to be completed before Thanksgiving. Expect to have an oral argument on it and hopefully a ruling before the end of 2024. I feel confident we'll be able to win that, and then that litigation will really off. So positive news in the MDL. Meanwhile, the first case in state court in California is scheduled to go to trial in the beginning of 2025. So we'll keep you updated as that moves forward as well.
Awesome. I know a lot of firms are excited about that tort. So I'll be interested to hear week over week what's transpiring. Okay, next, let's talk a little bit about Talc with the upcoming deadline. Share what's going on there.
Talc, J&J indicated that they're hoping to get 75% of the plaintiffs to agree to their bankruptcy prepackaged plan by July 26th. What's been going on meanwhile is a lot of fighting between plaintiffs' counsel and defense counsel. Recently, even J&J filed a subpoena to get information about financial records and loans to one of the leadership firms. Fortunately, the plaintiffs pushed back. They filed a motion to quash that subpoena, and that was granted. Also, we've been filing motions trying to get an injunction. The plaintiffs did. That was denied by the judge. So we'll see what happens in this litigation. It looks like they are going to file, but based upon the ruling in Purdue that we just got, we're feeling pretty good that the court is going to strike down that third attempt, but we'll wait to see when they file here in the coming weeks.
And lastly, Purdue. Tell us a little bit about Purdue's plan moving forward.
So in Purdue, we got the ruling from the Supreme Court at the end of June where they didn't approve the bankruptcy plan, in essence, because the slackers did not file themselves for bankruptcy, and they ruled that they couldn't get these third-party releases. So what happened then is Purdue's back to the drawing board here. Recently, they filed and were granted a stay of the litigation, a 60-day stay, where Purdue's negotiating with the slackers here to come up with a new bankruptcy plan that they're going to present and move forward. During this plan, we'll wait to see if the slackers themselves are going to have to file for bankruptcy, and then it's going to go through the bankruptcy court. So that's going to take some more time to work out. And like we talked on, maybe in this Purdue litigation, it was a little bit of disappointing news for some of the plaintiffs, but overall, that opinion from the Supreme Court will likely help plaintiffs in all of these other potential bankruptcies we're facing going forward.
Well, Joe, as always, grateful for you to spend a little bit of time on this Thursday, giving us the updates and insights on what's happening in the world of mass torts.
Thanks for having me, Susan.